on what his petition is all about. But my lord, we are opposing this petition on behalf of the 14th and the 15th interested party. And my lord, I think the starting point, as every council rightly began with, is Article 165(4). My lord, the only instance that you can satisfy is if it relates to 3B or B. And my lord, let us start with 3B, which is jurisdiction to determine the question whether a right or fundamental right in the Bill of Rights has been denied, violated, infringed, or threatened. My lord, I don't speak about the other petitions. I'm only concerned with the petitions of the Chief Justice. And my lord, when you look at that petition, you will not find a single valid averment that her Bill of Rights under the Constitution is being denied, or is being violated, or is being infringed, my lord. My lord, the office she occupies of Chief Justice, which is, the tussle whether she will be removed or not, is not an office that raises issues of the Bill of Rights. It's a very important office in terms of the constitutional architecture of the country. But the averment in her petition does not allege violation or threaten to violation her rights, my lord. My lord, this petition of the Chief Justice is about whether she will be removed from office or not. My lord, the second issue is to look at 3D. Roman 1 and Roman 2 are the only relevant ones, my lord. Roman 3 and Roman 4 are not relevant. Roman 1 says the question whether any law is inconsistent with or is in contravention of this constitution. Again, my lord, there is not a single law that has been pleaded by the Chief Justice to show or allege that is being contravening the constitution. So that again is out of the question. If we look at Roman 2, it says the question whether anything said to be done, my lord, and I emphasize the word done, under the authority of the Constitution or any law is inconsistent with or in contravention with the Constitution, my lord. My lord, my learned friend, Senior Counsel George Oraro, who appears for the petitioner, in that case, again, there is no averment of what has been done. My lord, the contradistinction here is not what will be done. The action that can cause or can give a party a cause of action under D Roman 2 is a question whether anything said to be done. And my lord, anything said to be done, the only relevant provision is 168 of the Constitution, which is the removal of the judges. My learned friend, my lord, does not plead a single issue done by the JSE that raises a cause of action. And my lord, I submit that the only cause of action that a judge can raise in relation to 168 is action taken pursuant to 168(4), where it says the Judicial Service Commission shall consider the petition, and if it is satisfied that the petition discloses a ground for removal under clause 1A, sends the petition. That, my lord, gives a judge a cause of action. But the petition here, the Chief Justice does not plead what the JSC has done, so that a serious question of constitutional law is raised, my lord. But my lord, although I'm fairly opposed to all the petitions being in Parliament of a judge, I'm vehemently opposed to the one of the Chief Justice, my lord. I think we have to create a distinction between these petitions. It is inconceivable, my lord, it is inconceivable for this court to make a determination that this matter raises a serious constitutional issues, and then you refer the matter to the Chief Justice. I was slightly surprised by the submissions by counsel for the JSC that the JSC has no problem with the chair of the JSC appointing judges to hear a dispute with the JSC. I mean, that's preposterous. How can he be ambivalent about that? But my lord, for my clients, I mean, my lord, if you transmit this matter to be raised in a serious issue of constitutional law and the file goes to the Chief Justice, my lord, she will have about 120 to 130 judges to pick. She will do a thinking process as a person, as the petitioner, as a person interested in the outcome of that case. The Chief Justice is very much interested in this case. She wants this petition to be allowed. She wants her petition to be allowed, my lord. She wants her petition to be allowed. And then, this process will lead to a process where she will pick the judges out of 120 judges or 130. She will pick 3 or 5 or 7. And my lord, there is a thinking process she will do. She will start with one and say, this one for X or for Y, I'm not including him. It's just humane. She will go to the next judge. She will say, this X or Y, I think you should hear my case. And that process, my lord, if you certify that her petition goes to her for an empanelment of an expanded, I mean, that would be an epic scandal. It will be an epic scandal. It will be taught in law schools. It will be taught everywhere. I mean, it is simple. I mean, it is allowing a judge to pick a judge of a choice to listen to a case, my lord. My lord, and I think that is where my learned friend Musangi, when he said that the process of empanelment is an administrative process. If it was a judicial process, we would have said that the Chief Justice would be constrained by certain constitutional principles. But I agree with my learned friend when he says it's an administrative process. In that administrative process, when she is undertaking the process, there is nothing that controls her thinking process, my lord. My lord, my learned friend, I think George Oraro and Dr. Yundi said that there are many other courts, there are many other cases in the courts. It is true, my lord, there are many other courts. I'm not a party to them, but they are there. But my lord, those courts validate private rights under the Bill of Rights. They are private rights. In contradistinction to what is in this court, my lord, is about removal of judges. They are in two different realms of the law. My lord, the other thing, there's, I think it was the petition by Justice Lenaola. My lord, a hypothesis never forms a course of action, and more so a constitutional course of action. My lord, both the Chief Justice and Lenaola are saying that if we are removed and then we want to appeal to the courts, the Supreme Court will not be there. My lord, that's a hypothetical situation. It might arise, it might not arise. It's only when it arises that a constitutional right comes into play. A hypothesis that some event may happen can never form the basis of a constitutional petition. It may or it may not happen. It is a theory, my lord. My lord, with those, lastly, I think it is my learned friend George said that this case, he says so many things that they are very important issues of law. He said, for example, one, whether the JSC is above the Constitution, my lord. My lord, that is a unilateral self-construct of the Chief Justice petition. She is the one who is raising that question, whether the JSC is above the law. It's not factually true, because the JSC is a creature of the Constitution, so it's not above the Constitution. And it is doing, my lord, a constitutional mandate. But the Chief Justice is just being sensational when she says that the question she is raising is whether the JSC is above the Constitution. My lord, in fact, if you look at the petition, and I can read the paragraph word for word, the Chief Justice pleads and says that the Supreme Court judges are above any, the right words I can't remember, but it says, my lord, that the judges of the Supreme Court cannot be subject to a disciplinary process under 168. That is what the petition of the Chief Justice says. And my lord, yes, you want me to read the paragraph? Okay. My lord, just give me out.
Sorry, sir. I'm further aware that the respondent is established in Article 171 of the Constitution. Sorry. It It's actually the lordship. It says the first respondent does not, whether by virtue of provisions of the Constitution or any other provisions of law, have the jurisdiction to entertain, consider, or deal with any petition against judges of this court.
My Lord, also 139. Let me read it. It says 139. I think of the petition, my Lord. Yes, of the petition, my Lord. It says, according to the Chief Justice, my Lord, she says, and Article 168(1) of the Constitution does not grant the JAC, the first respondent, any power to intervene or determine any issue on the exercise of the powers of the Supreme Court, whether judicial, functional, or institutional, my Lord. My Lord. No, listen, my Lord, let me read for it. I mean, it speaks for itself. Article 168(1) of the Constitution does not grant, and that's, my Lord, the provision that for the removal of judges. 168(1), my Lord, it says she pleads under Article 161(8) of the Constitution does not grant the first respondent any power to intervene or determine any issue on the exercise of powers of the Supreme Court, whether judicial, functional, or institutional. And my learned friend, I think when he was saying the question we are determining is whether the JEC is above the law, I think the proper question is whether the Supreme Court is above the Constitution, as he has pleaded in this paragraph. So, my Lord,
So, paragraph 6 of the affidavit, Mr. Musota, you say
This is paragraph 13.
yeah, that is.
It says, I verily believe, rather it says, I verily believe that petitions contravene the provisions of the Constitution and violate my fundamental rights as enshrined under the Constitution. In that, 13.1, the first respondent does not, whether by virtue of the provisions of the Constitution or any other provisions of the law, have the jurisdiction to entertain, consider, or deal with any petition or claim against judges of the Supreme Court as constituted under Article 163.
so my Lord, finally, finally, my learned friend says that the issue, yes, but final, my learned friend is, yes, madam, I'm sorry.
Not. Yes, I will. No problem.
Yes, my Lord, finally, my learned friend George Oraro says that the issue that will be determined is on the issue of decisional independence of the Supreme Court. In other words, certain petitions, my Lord, are questioning the decision of or the judgment of the court, my Lord. My Lord, when you look at the interested parties' reply in affidavit, sworn by Hilda Mulwan in Dolo, sworn on 10th March 2025, and my Lord, you look at paragraph 12 of that affidavit, my Lord, the 14th and the 15th interested parties, my Lord, were admitted to the bar in November last year. But because of paragraph 4 of the letter that was addressed to me, dated 18th January 2024, my Lord, that paragraph 4 reads, it says, in view of the foregoing, it's the decision of this court that henceforth and from the date of this communication, you will have no audience before the court, either by yourself, through an employee of your law firm, or any other person holding brief for you. So, my Lord, so any person like the 14th and the 15th interested parties who were admitted to the bar in November 2024 and who were employed in my law firm have become victim of this directive. And my learned friends want to tell us that that is decisional independence that cannot be challenged under the Constitution. I mean, that's preposterous, my Lord. My Lord, that's the end of my submission, my Lord. I'm most thankful, my Lord, for the court's accommodating me. My learned friend, Hilda, will hold my brief. My Lord. Yes, my lord, I can't speak for the other petitions, but I can speak for the petition by the Chief Justice. The Chief Justice petition is that nobody can question the Supreme Court on anything. That is what our petition is about. It's an interesting reading. I must oblige, my lord.